speaking, with me, Tarun Nangia. Now we commence the part 3 of the all-important judgment, which refers to the modification of arbitral awards under Section 34 or 37 of the Arbitration Act. Of course, there is a dissenting judgment by Justice K.V. Vishwanathan that also should be discussed on the show, will be brought up. But it is a very important judgment, and this is why we do the third part on this series. And we're going to now discuss the points that earlier weren't brought up and what is the analysis. And I have three eminent panelists with me. I want to welcome Justice Rishikesh Roy. We all know he's an arbitrator. He works in the field of arbitration and also legal advisory on strategic issues related to law. Earlier, he has served as a judge of the Supreme Court of India and rose to become the member of the all-important Collegium of the Supreme Court, and earlier has also served as the Chief Justice of the Kerala High Court. Good to see you, and looking forward to some interesting insights from you. I have with me today on the show Justice M.M. Kumar, who we all know earlier has served as the Chief Justice of the Jammu and Kashmir High Court. Before that, and after that, he became the first president of the National Company Law Tribunal, which he virtually set up from scratch, and of course handled, as they call, the dirty dozen cases and adjudicated. Good to see you, and looking forward to some interesting insights from you as well. We have Senior Advocate Kadambari Singh with us. She practices at the Supreme Court of India, the Delhi High Court, and other forums, and she will bring her expertise on the subject, because she also deals a lot of time to ADR, which is arbitration. Good to see you, Kadambari, and thank you for your time. At the outset, let me request Justice Roy to give the opening comment on this judgment before we move on to other comments. Over to you, sir, for your opening comment.
Before I make my opening remarks, this is the third segment of discussion on this particular judgment. Now, this is a 5-member bench. Are we to understand that you will have at least 5 segments of this particular panel discussion on this judgment, because there are 5 judges? All right. Now, having broken the ice with that initial comment, if I may just put the issue in context. Now, when we have arbitration, as we all know, and Tarun's program is not only looked at and seen by people who are connected with law, but even other people who may not be as familiar with the field of law, they also look into this program. So I thought that maybe 30 seconds on just the understanding of what arbitration is all about may be in order at this stage. Now, arbitration is part of the alternate dispute resolution process, which is envisaged by the laws of India. It is a departure by the parties' consent to avoid the litigation process, which is the common way for resolution of dispute through the courts in India, the different hierarchical forums. So people opt for arbitration. And once you opt for arbitration, it is a decision taken by the parties themselves. They choose the arbitrator, and thereafter an award is pronounced. So therefore, the law under the Arbitration and Conciliation Act 1996 is very clear as to under what parameters you can put an award under challenge. The courts in India have evolved a rule of interpretation which would advisedly warrant the courts to form, to interpret matters, a legislative enactment, by looking at strictly the provisions of the enactment. Now, Section 34 and Section 37 are the two relevant sections which come into play whenever a particular award is challenged. Now, The judgment that we are concerned with, Gayatri Balasamy versus IAG Novasoft Technologies Limited, is a judgment which actually tried to answer the uncertainties that prevail amongst the stakeholders as to what is the scope of interference by courts while exercising powers under Section 34 of the Arbitration Act. Now, Section 34 provides in clear terms what are the parameters, under what circumstances an intervention is permissible by a court, and those are well known. The Arbitration Act itself provides for, under Section 33, corrections and interpretation of the award. That is a stage which is before 34. Now, 34 would apply to those circumstances for setting aside an arbitral award. Now, the majority judgment in the judgment that is under discussion has held that the power given under Section 34 to set aside the award would also include that court has a limited power to also modify an arbitral award. Now, this is a key finding of the majority verdict. Now, it is also said that when there are, say, decisions on multiple causes, let us say causes 1 to 5 are there on which an award is passed. Suppose the fifth issue is severable, which is a defective issue, which is a defective decision, which is severable from the other decisions on 1, 2, 3, 4, then that can be set aside by the court exercising power under Section 34. So severability is one of the aspects that is spoken of. And also the court has said that it can also alter the interest post-award. So that is another very significant aspect. Now, court also has spoken about exercise of power under Article 142 to do complete justice. That power is vested exclusively in the Supreme Court, only on the Supreme Court of India. Now, when these are the parameters laid down by the majority opinion, the minority opinion penned by Justice K.V. Viswanathan has, however, interpreted the provisions of Section 34 and also the limited power of court's intervention in a challenge to an award by saying that power to set aside an award under Section 34, provided the circumstances merit, will not mean that there is also a power to modify the award. Now, that is a very key takeaway from the judgment of Justice Viswanathan. And since we are in the third segment of the discussion that Tarun is, spearheading from legally speaking, we have had the erudite opinion of Justice Arjan Sikri, one of the most respected arbitrator and a former judge of the Supreme Court. Also, another equally erudite and respected judge, Justice Sanjay Kaul, and the panel in those two segments. And I've had a glimpse of those discussions also. But putting these preliminary aspects for consideration by the very eminent panel today, Justice M.M. Kumar and Kadambari, I would now perhaps ask Tarun to request their own comments, preliminary comments on the discussion that we are having right now. Tarun, you have to unmute yourself, I think. Not able to hear you.
Thank you, Justice Roy, for your opening comments and shedding light on your views on this all-important judgment that concerns arbitration. I'll go to Justice M.M. Kumar. Now, you do a lot of arbitration and opinion work since having debated office at NCLT. And we have, I think, often than not spoken about various developments in arbitration, even over phone calls or when we meet. So, when this sort of a judgment comes, what are the first few things that cross your mind when you, what kind of impact do you see it will have on your work? Because obviously, when court has a power to modify the award sort of, or sever parts of the award, because power of severance is a very big power. What kind of impact will that have, or any other point from the judgment that you would like to bring forth for the promoters, the GCs who are watching the show, because they would like to know the impact of such an award, such a judgment. Yeah.
Very well, Tarun. Thank you for granting me opportunity. I would like to discuss this judgment in three parts. One, Section 34, second, interest, and third, 142. Although discussion has been there in the earlier two episodes, Justice Sikri, Justice Kaul, I also had the advantage of listening to those two programs, and I must greet you, congratulate you for bringing to the focus all these issues. Now, if we read carefully the majority judgment, at the first instance, the majority judgment tried to confine itself to the statutory flavor of Section 34, 1A, Roman 4. That is a provision made by Section 34 that on the ground that if the award is not within the scope of the arbitration reference, then naturally it will be considered, it will be a jurisdictional question. It has to be, that part has to be set aside. Because 34, 1A, Roman 4 deals with only this much, that if there is a question before the arbitral tribunal, issue before the arbitral tribunal which is not contemplated, which is not referred, or which otherwise does not arise, then that part has to be set aside. That is statutorily built in, and judgment in Hakim's case, that was famous judgment relied upon. But the vexed question, which from para 29, 25 to 35, the majority judgment has confined the discussion to this aspect. Now, if you read para 25 of the judgment, but the judges try to say, the bench tried to say that let us see how far we can weave into Section 34 the principles of equity and justice. Now, there is a difficulty for any legal scholar when they talk of equity and justice in para 25, then naturally what comes to mind is Section 28(2). Subsection 2 of Section 28 expressly exclude equity, justice, etc., etc. Now, the fallout is, in the commercial world, the party's autonomy has to be respected under the arbitration law. And 28(2) also says so, that unless parties say so, and tribunal cannot assume the jurisdiction to say that I will decide on equity, justice, and fair play. That is excluded. Now, the commercial world, when they draft their contracts and incorporate an arbitration clause, they are careful of all these legal nuances. They have a legal team to back up. If necessary, they go to experts. Now, that certainty is also disturbed when the court says that the award can be set aside on the ground that it is manifestly, it suffers from manifest error. If we read para 85, where the conclusions are recorded, the valid part, when the award is severable, by swearing the invalid portion from the valid portion of the award. Now, the validity and invalidity is a question under 34. We cannot reappreciate evidence. Like First Appellate Court in the ordinary civil code, when appeal is filed under Section 96 against the judgment of a first trial court, then First Appellate Court has the jurisdiction to appreciate evidence, law, etc. But for facts, it is a final court. In second appeal under Section 100, nothing can be done. But here, the use of this expression is going to give rise to arguments that a valid and invalid portion, would it be confined to the areas which has been used by statute under 34 1A Roman 4? But this judgment go much further. If we start reading from para 36 onward, the discussion is whether modification is amount to setting aside award partly. Conclusion is yes. Setting aside award and setting aside partly, these two expressions have been used. So this is with regard to, and then corrections under 33, which could be carried by the arbitrator. The sanctity of the arbitration is that everything has to be left to the discretion of the tribunal, arbitral tribunal. And after pronouncing the award, publishing the award, it becomes functus officio. Under 33, within a month, errors, corrections, and even computation, all that has to be done by the arbitrator. But now it has been given to, under Section 34 also, to the court. So in a way, 33, 1 month stand expanded further under 34. Now, second is with regard to interest part. Interest part, as everybody knows, 37(1)A, 37(1)B, particularly the post-award interest. Now, arbitral tribunal is one forum where the tribunal had a chance to see everything happening, the demeanor of the witnesses, the evidence produced, documents produced, and various types of other factors which weigh in the mind of the arbitrator, which may not be legally, otherwise sustainable. Those factors weigh even when he award interest. So even tinkering with the award of interest, unless it is against the statutory requirement under Section 37(1)B, the normal rate of interest plus 2%. If it is higher, this will be statutory violation. So that may have to be corrected under 34. But otherwise, to a discretion once it has to be respected to my mind. Now, 142 in commercial arbitration, I don't think 142 can be invoked.
Okay.
142 is to do complete justice within the parameters prescribed therein. In a commercial arbitration, where the party's autonomy is there, to invoke 142, I have my doubts about that.
Point very well taken. Thank you for giving this detailed opening comment. We'll go to Senior Advocate Kadambari Singh for her opening observations on this important Gayatri Balasamy judgment on the issue of modification of arbitral awards. Over to you, Kadan.
Thank you, Tarun. And in fact, I think while discussing earlier, I had expressed my views that I wholeheartedly welcome the majority view on the judgment, which in fact I hoped would come in the way it did, in the wake of extreme hardship and uncertainty that the parties go through in arbitration. So the parties who are engaged in arbitration, they are spending all their time and money. And then finally, when the award comes, and in India, we know the quality of awards. We've seen the award passing, having references to absolutely illegal kind of directions are being passed. There was a case when I was dealing with which referred to compliance of the personal obligations of the party, the personal qualifications. So there was an award which actually directed compliance of personal services by one of the parties in perpetuity. So these are the kind of illegal awards that we are faced with. And more than 50% of the awards as it is find themselves relegated to a fresh start if they are set aside. So I think the majority view secures the loop of the lists and provides a way for the dispute to conclude, allows it to acquire finality, and it brings about a quietus to the dispute. Now, to explain myself, let me give you a hypothetical situation which would come about if there was no power to modify in the court. Now, if there is an award which is beset with the patent illegality or any of the grounds which are given under 34(2), and then thereafter it is set aside, then again parties are relegated to a fresh start. Again, the award comes. The second award will also may or may not have potential issues. Then third time, then fourth time. Does the minority view contemplate that this kind of a process continues forever in perpetuity? I think the majority award, and this is the strongest argument in favor of the majority view, that there has to be a conclusion, and there is a rule of conclusiveness of lists. But this particular, if we talk about the minority award, while it is very compelling, I've read of course the entire judgment. The portions of the minority view are written very convincingly. They're very compelling, no doubt. And the fundamental approach of the minority view comes from focusing on the sacrosanct quality or sacrosanct division of the powers between legislature, judiciary, and executive. And again, there is a refrain by the minority in the minority view that if the power of modification should be there, it should be left to the legislature. Now, that is the conceptual difference between minority and majority view, whereas Justice M.M. Kumar rightly stated that the majority view has approached it from a viewpoint to weave in the principles of equity and justice and not offending the jurisdictional fabric of Section 34. Now, if we come to the three basic aspects of minority view, now let me attempt to take up three broad aspects under which the minority view has given its part of the judgment. One is the legislative will, as I said, legislative will as gleaned from the construction of the provisions, specifically Section 5, read with Section 34. So Section 5 contains non-obstanta clause, and Section 34 says only set aside. The powers only to set aside is there. The second part of minority view is based on the rule of interpretation, saying that a plain and natural meaning has to be given to the statute. Now, the third part is that minority view stresses on is the primary objective of the Act, which, according to the minority view, is least judicial intervention. Now, if we look at the objectives, so let's look at the objectives of the Act, and let's look at Section 5 also for a minute. The key objectives of the Arbitration and Conciliation Act, I've just got the Act with me, are as follows. So the second key objective, first is, of course, minimization of the supervisory role of the courts, right? The second one is providing speedy disposal of the disputes. Now, if the dispute has the potential to go on and on and on in perpetuity, then I'm sure this is conflicting with this particular key objective. The third objective says Act provides for an amicable, swift, again the word used is swift, cost-efficient settlement of the dispute. The fourth one says resolving dispute by formal award of the Court of Arbitration. But the sixth one, I'll come to the fifth one, says it is an act that regulates, I stress on the words regulates, the domestic arbitration. Now, regulation has to be done, of course, by the courts. And the fifth one, which is again very important, the fifth key objective says ensuring that the arbitration proceedings are fair, just, and effective. So therefore, when we see the approach of the majority view, which says to weave in the principles of equity and justice, this is in consonance with the objectives of the Act itself. Now let us come to the non-obstanta clause, the provision, which is Section 5. So I'm just reading it for a minute. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part. Now, the stress on the word should be in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Now, the issue that was before the majority as well as before the constitutional bench was interpretation of this along with 34. Now, Section 5, while it says that what has been provided in the Act, that must be done in that manner. But it does not contemplate that where the Act is silent, then the court cannot provide, fulfill the gap, which is there, obviously there. So if we read the objective, the rule of conclusiveness, if we read even this non-obstanta clause, and then we go to Section 34. 34, now, again, there is another clause, 34.4, which has been greatly debated. Now, here also, if the arbitral tribunal is rendered functus officio for a minute, now the court has been given the power under 34.4 for sending the dispute only during the proceedings of the challenge proceedings back to the same tribunal to again scrutinize and fill in the gaps which are there, whether partially or fully. So now this again gives a bigger power to the court. If the court, and then if you read 2E, this is the last one I'll read, because if in the interest of time, if you see the Section 2E, which defines court, it says includes High Court, the Civil Court of Original Jurisdiction includes High Court in the exercise. Now the words are in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide questions forming the subject matter of arbitration, as if the same is the subject matter of a suit. Now, if we see all this conjointly, and I'm sure the objectives of the Act have to be brought into force. Now, when we look at the legislative will, specific reference in the minority view is that because in the 1940 Act, the power to modify was there, but it was taken away in 1996. So therefore, the intention of the legislature is specifically to not to have the power to modify. Now, here I would just like to say this, that first of all, I would, and then there is also a reference of international norms as derived from Arbitral model law. So I think if you see all the jurisdictions major arbitration jurisdictions in the world, Singapore, London, Australia, New Zealand, all of them have given in their statutes the power to vary and modify, in fact, to the extent that the powers given to the courts are akin to being an appellate court. Now, if India wants to look at international norms, then the current trends have to be gleaned out. And secondly, there have been various committee reports recommending to our policymakers to bring in the power of modification so that the process can be expedited. But if if the legislature does not bring in such a law and still leaves the gap, it is for the court to supplement. Now, there is another, and this is, I know I've been going on and on about various sections, but one last thing I'd like to say is that in one of the paras, the court had even relied upon the principles of construction, causes omissus, and the other one reading to the statute as a whole. So even there, if the statute as a whole has to be seen, then the majority view is justified, completely justified. I think I'll mention various other aspects later.
Thank you.
This is my
Thank you for the opening comment. I'll now go to Justice Rishikesh Roy to ask him, in addition to what he wants to say, two questions. Most of the disputes actually happen also on the interest cost. And the court here has power to modify post-award interest. Would that amount to modifying the award, or in his view, it is not true? And the power of severance. How arbitration is successful? Would it depend on how, in a sense, restrained the courts are in using these both powers? Over to you.
Well, Tarun, considering the very huge sums that are involved, mostly in the arbitration proceedings which are conducted, the element of interest, when it gets added to the principal sum, it actually becomes very often the substantial part of the award. So therefore, to say that I will interfere with the interest component, it is again a disturbing thing, because you are permitting discretion to be exercised by individual judges on a challenge to Section 34. A Judge A might think 9% interest is good. Judge B might think 6% interest is good. Now, what are the parameters on which the interest component is to be understood? So perhaps there may be a need for certain parameters, maybe a legislative exercise, that in a given situation, this could be the interest component. Now, I would also like to comment on the equitable principle that Kadambari has so strenuously highlighted in her comments. Now, we are having a scenario of, let us say, a principal employer and an employee, a contractor, negotiating hard-nosed negotiation leading to execution of a certain contract. The terms of the contract specifies that there will be an arbitration. On the basis of that contract, when dispute arises, an award is passed. Now, the party which is not happy with the award, which is a result of the hard-nosed agreement between the parties, a contested arbitration process by an arbitrator chosen independently by the parties concerned, then for the parties to again come and say that the award should be set aside or partially set aside or changed, that becomes a little difficult thing. Now, one important aspect that Kadambari highlighted, which I would like to again say once more, the legislature in UK, Singapore, Australia, and perhaps a couple of other jurisdictions have specifically given this particular power to the court on a challenge to an award. we had the recommendation of the Viswanathan Committee. Despite the recommendation of the Viswanathan Committee, the Indian legislature did not incorporate this particular power while enacting the Section 34 jurisdiction. Now, we have also seen the extent of judicial intervention under Section 5. It provides for a non-obstante clause, as is already highlighted. And when commercially contested matters reach to a conclusion in the shape of an award, to say that it will lead to finality and conclusion when you are permitting repeated challenge to the award and then setting aside partially or modifying the award, that again becomes subject to judicial challenge. So I don't think there is going to be any conclusion reached. So therefore, I would personally prefer that the hands-off process, which we always sort of say because parties have agreed for arbitration, so there should be a limited or very limited scope for court's intervention, should be the norm. Because if we accept the majority judgment, it is actually marks a shift and a major shift towards increased judicial intervention, and particularly in the context of what is stated in paragraph 49 of the majority judgment. Judicial intervention is permitted or envisaged only on situation when court notices other manifest error. Now, this is a very term of broad understanding. Now, any judge might be able to reach a conclusion that there has been a other manifest error in the award, which will permit the judge to intervene with awards. And I think that is not how the shape of giving encouragement to arbitration in our country is going to be of much help, because the parties, they have decided and they have reached award on the basis of their own understanding. And if they are to be disturbed because there is manifest error as perceived by a judge, I think you are going to turn the clock back. And unless there is a legislative intervention, I don't think it should be done.
Point very well taken. I take the same question to Justice M.M. Kumar on the issue of severance and the interest cost. At a time when sometimes after the award is passed, it may take 10 years in court. It's very sad, but sometimes it does happen that, you have awards being adjudicated then and challenged in courts, which go for many years after, in fact, more than 10 many times. So your views on this?
Very well, Tarun. So as far as the interest part is concerned, if the matter remains pending in the courts beyond a particular period of time, say 5 years, 6 years, 7 years, one, there is no fault on the part of the successful person in the arbitration who has got the award in his favor. Secondly, if 7 years delay is there, 5-year delay is there, then he is also deprived of use of his money. So keeping in view the inflation or price index, that money is also losing its value over the period of time. So therefore, to say that the time should be a factor taken into consideration for reducing the rate of interest, unless, as I said earlier, it violates the parameters laid down in Section 37, unless that parameter is violated. Otherwise, I don't see any reason for tinkering with the rate of interest given. And I feel that what Justice Roy has observed, that once the parties out of their own volition has entered into an agreement and has provided for a particular type of contract, chosen an arbitrator, the award has to be respected as it is. You see, when a contract is drawn, as I said earlier, in the commercial world, there is always a team, lawyers team, to scrutinize each word of the contract. And it is after the legal advice standards that the contracts by both sides are entered into. They are with their eyes wide open, they enter into the contract. So it is not that the equity justice has to step in for deciding the issues before the arbitral tribunal. Equity justice have been specifically excluded by Section 28, subsection 2. So therefore, the sanctity of the contract, it is not like unfair terms contract. In England, there is an act called Unfair Contract Terms Act 1977. So there a clause in a contract, consumer contract, like a consumer contract, if there is a unequal bargaining power, that area may be available, but not in arbitration, where the commercial contracts are entered into, and the otherwise what will happen? An element of uncertainty will enter, and no legal team will be able to advise correctly, because what they advise on that date, as per the law prevailing, and if it is to be modified later, the award is to be modified later, then see why legislation is required. Because once the legislation comes, it operates prospectively. Judgments of the courts, they may, if the judge-made law is applied, and it is applied to the existing dispute which has started, say, 5 years ago, 4 years ago, then it brings uncertainty. The commercial world cannot risk this type of situation. A commercial man, a commercial company would not know what is going to be the law after 3 or 4 years. So he has to act in accordance with the term and condition which were valid on the date when they entered into the contract. That is why one of the panelists in earlier discussion, Mr. Janawat, one of the GC, he was mentioning that in commercial world, certainty has to be there. The time factor, effective enforcement of the award, and least interference by the court. To make India a hub of the arbitration, I think these factors need to be strengthened. And the Vishwanathan committee recommended modification. Legislature did not accept it.
Yes.
In 34, they could have easily incorporated that provision, as my elder brother Justice Roy have highlighted. So even now there is an amendment bill pending before the parliament. It can now be done. The benefit of the legislature intervention and the judicial intervention have different repercussions, as I explained. So the interest, as far as cost is concerned, cost is well known. Statutorily, it is provided that the losing party has to suffer the cost.
Point very well taken. Thank you for explaining this in your view. We'll go to Senior Advocate Kadambari Singh for her intervention on these two things.
Yes, I think Justice M.M. Kumar, former Justice M.M. Kumar and Justice Roy, both have referred to the sanctity of the contract, which is absolutely correct, because arbitration is a parallel legal system which can work only, yes, if there is a certainty in contractual, the outcome of the actions of the party under a contract. However, what we sometimes lose sight of is the fact that in a lot of contracts, there is a dominant party, and which is a practical reality. And there is a party which will be given the terms It happens when you see very large PSUs. It happens when there are large investors, foreign investors coming in. So the dominant party will dictate, and sometimes you will find terms which are totally onerous. Now, however, notwithstanding the fact that, yes, the sanctity to the contract must be given, there is another aspect to it. The majority view has spoken about the right to modify, but it is a very limited right. It does not say that the right to modify can be such that would change the complete contractual understanding between the parties. So we have to see that even the modification power is with the rider, that it has to be manifestly illegal. Now we find another practical reality in Indian arbitration domain is that when we see awards, they are passed they are passed in a manner which completely negates the fundamental law of the land. Therefore, there is a large number of awards as opposed to even other jurisdictions, which in fact give the permission to modify. Here in India, a large number of awards suffer from such illegalities, which are opposed to public policy or fundamental of the land, that ultimately they have to be set aside. So the core issue is that what will really cause hardship and what will facilitate a speedy justice, because ultimately it is supposed to be speedy, expeditious, and to minimize the hardship. Now, in para 72 of the minority view also, minority view recognizes this aspect in para 72 when it says that this can be done. So there's a very limited scope where the court can read into a provision and supply something which is missing. When the administration of justice results in absurdities or injustice. So, in fact, para 72, if we read it, understands that this position can take place. And I've already given that hypothetical situation where an award comes, it is set aside, again, arbitration is started afresh, again, an award comes, it is set aside, there is a possibility. So, that is more of an uncertainty rather than the courts exercising the powers where a just outcome can be given, and the parties to a contract should not be apprehensive about not getting a just outcome from the courts, but it would just shorten the process. That is my perspective.
Thank you for that comment. I think we are out of time, but it was indeed an engaging discussion on the part 3 of this Gayatri Balasamy judgment, which deals with the modification of arbitral awards. The last word on this issue is not over. India, as we know, is going from a $3 trillion economy to a $5 to a $10 trillion in the coming years. The disputes are going to explode. In any growing economy, the disputes and so the arbitration, this is going to increase by leaps and bounds. I hope and pray that we have enough arbitrators and enough judges to take care of this caseload that will be generated. And that is why any judgment passed will see, in a sense, how it is fair in the next 2-3 years. We'll easily come to know. Sometimes even in the next 6 months, we may come to know the impact, and we will thankfully, in a sense, with the intelligence of the panelists, get to discuss that how this judgment looks at 6 months from now. And, because I think there may be many practical aspects where Justice Roy, Justice M.M. Kumar, and Senior Advocate Kadambari may come across 4 months from now that they don't know today. What comes? Computation being one point, that is there in the judgment. So I think that will be a cause for another discussion and a show. But I would like to thank Justice Rishikesh Roy, Justice M.M. Kumar, Senior Advocate Kadambari Singh. Thank you for your time, and thank you for sharing what you think about this judgment and contributing to this discussion that will lead to the development of ADR and arbitration in India. Thank you so very much. Thank you.